Hello and welcome to the Southern View. The top focus this evening, a wrap for governors delaying decision on bills from the Supreme Court. We'll also have a special focus on whether foreign university campuses can change the face of higher education in India. All that up ahead, but first, a quick bit of breaking news from Karnataka. B.Y. Vijayendra, the son of BJP strongman B.S. Yediyurappa from Shimoga and Shikaripura, has been made the Karnataka BJP president. Remember, this decision has been kept in abeyance for a long time now, ever since the party's rout in the assembly elections. And this appointment is quite interesting. It's a reiteration of the B.S. Yediyurappa power. Remember, Yediyurappa was asked to step down by the BJP mid-term because he crossed the age of 75. Now that B.Y. Vijayendra has been made president of the party, it's a reiteration of the BJP's effort to consolidate its Lingayat vote base ahead of the 2024 polls. Also, given the alliance with the JDS, which represents the second largest voting bloc, or the Vokkaliga caste, the BJP hopes that this combination is the one that is going to ride it through in the 2024 Lok Sabha polls. Obviously, there'll be several reactions, but that bit of breaking news coming in from Karnataka this evening. Well, now to that important judgment, and one that may have impact in several opposition-ruled states where governors have withheld assent to bills passed by state legislatures. The Supreme Court today held categorically in the case of Punjab that a governor cannot withhold assent to bills, doubting validity of legislative sessions, as it happened there. The court asked Punjab Governor Banwarilal Purohit to decide on bills submitted to him for assent. Punjab had moved the court after the governor refused to decide on bills, including money bills, questioning the validity itself of the legislature session. The court had strong observations in this regard, even observed that such actions are playing with fire. On Tamil Nadu's petition on Governor R.N. Ravi withholding sanctions to bills passed by state legislature, the three-judge bench led by Chief Justice Chandrachud observed that it is a serious concern. The Tamil Nadu government had brought before the court that 12 bills, some as far back as 2020, sanctions and remissions requests for life convicts were pending before the governor. It had sought an outer limit time frame from the court for governors to decide on bills. Kerala had also moved the court against its governor withholding bills. Solicitor General of India, Tushar Mehta, sought a week's time from the court for the centre to suggest a solution under the constitution. He told the court that the centre wants a solution and not contention in these cases. Interesting comments there. Joining me this evening, my senior colleague Sunil Prabhu, who's tracked this case very closely. Sunil, first is the judgment as far as the Punjab case is concerned, and then, of course, the observations as far as the Tamil Nadu writ petition is concerned. Extremely interesting also what the centre has told the court today.
That's right. In fact, they didn't agree with the Solicitor General, who really requested for more time and went ahead and passed this order. So this is clearly a strong message to governors who are basically presidential nominees. There's the centre's representative in the state, and the fact that they have been, and as you rightly pointed out, from state to state, from Kerala to Tamil Nadu to Punjab, and the list continues in opposition-ruled states, which really strike at the root of federalism. The fact that the governors are refusing to pass and clear bills is in a clear contravention, as the Supreme Court pointed out, to the power of the people must remain in the Legislative Assembly, and they have really the right to decide. And it's not for governors to act as they have been doing so. And it's in that backdrop that today's order has come on the governor, Mr. Purohit, to take a decision. Really, while there might be a big legal question on the prorogation issue, that they will address at a later stage. But the fact that when bills are passed in state assemblies and you refuse to give and assent to it, it's a clear sign that all things are not well, and it strikes at the very root, as I said, of the federal structure.
Interesting comments there by the Solicitor General there, Sunil. What's the sense that you're getting in terms of the centre's thinking? Because Tamil Nadu, in its petition, remember, has said that it's undermining the will of the people when a decision of the state legislative assembly is not sanctioned by the governor. It has also pointed out to other sanctions and remissions of prisoners which are pending before the governor. What's the thinking that you're picking up of the centre in this?
Well, the center is making a very, very clear distinction. They're very different in terms. They're not really defending the role of the governor. They're looking at it in its entirety. And if you recall, Governor Ravi had actually been rapped by his knuckle when he tried to dismiss, without the recommendation of a chief minister, a minister, and then had to go back on that entire decision because the center was definitely not in agreement. So it's in that backdrop that the center has definitely taken a very different position. They want to find, and that is why the Home Ministry required some time. But of course, the Supreme Court said nothing doing at this present juncture.
Right.
We need to allow governance to carry on and ensure that state assemblies which have passed bills, the people get those bills and get it enacted at the earliest.
Right. Thank you so much, Sunil Prabhu, for those details. Also joining me this evening is Mr. P.D.T. Acharya, former Secretary General of the Lok Sabha, constitutional expert. Sir, my first question to you is the interesting submission of the centre before the court. It says that the Solicitor General has said that the centre wants a solution and not a contention in this case. What could be a potential solution, given that there seems to be delightful vagueness as far as how soon a governor should send back a bill to the which has come to him for assent?
See, under Article 355 of the Constitution, it is the responsibility of the centre to ensure that the government of the state is carried on in accordance with the Constitution. And that means whenever there is a constitutional problem, breakdown in the state, it is the duty of the central government to ensure that the constitutional machinery in the state runs smoothly. Now, in this particular case, there is in fact a constitutional crisis kind of situation when the governor does not give assent to the bills which are passed by the assembly. When that happens, there is in fact a kind of a constitutional crisis created by the governor and not by anybody else. Normally, a constitutional machinery breaks down because of the failure of the government there. But in this particular case, I must say that it is because of the action of the governor or inaction of the governor. In fact, they are sitting on these bills for quite a long time. And therefore, this is a very unique kind of situation where the central government has to step in and direct the governor to take a decision immediately. That is what the central government can do under Article 355.
All right, that's an interesting point, important point that you make as well. I just want to draw your attention also to the fact that this is not restricted only to the bills. Of course, the arguments today were restricted to the bills being delayed decisions. But you see, there are sanctions, and for instance, in Tamil Nadu, they've brought in remission requests before the governors which are pending. So what can happen on those very quickly before I move forward?
Well, the governor, under the Indian Constitution, the governor has to act on the aid and advice of the Council of Ministry. And the Supreme Court has, in a number of decisions, said that the governor has no executive power to perform independently. He can act only on the aid and advice of the government. And if the government advises the governor to do a particular thing, then the governor is required to act in accordance with that. And that explains everything.
That's right. Shamsher Singh versus State of Punjab is a case that's been pointed out several times. Thank you so much, Mr. P.D.T. Acharya, for those thoughts there. I'm also now joined by Advocate of the Supreme Court, Mr. Sanjay Chadda. Sir, thank you so much for joining us. As I was posing to Mr. Acharya, the question that I want to ask you is very simple. What can the centre do right now, given that it's made the submission before the court? And how do we solve this ongoing, long-standing confrontation between governors and state governments, especially in opposition rule states?
I want to first clarify one thing which is very, very important from the audience point of view. I'm sorry, I'll reply to your query. It is a one-line answer. Now, as very rightly said, that governor is the constitutional head of a state and he has to act in aid and advice of the cabinet. Now, in the case, let's say a bill is given what will happen? There are three options. Article 200 very specifically provides for three options. One is either he gives the assent. Second, he returns back with his own suggestions of amendment or whatever he wants to say on the bill to the assembly to either do the needful. And third option which he has is send it to the president for the assent. Now, what is the time given? Our constitution is silent on it as to within what time it has to be returned back. The constitution says as soon as possible. But what is the meaning of as soon as possible? The constitutional makers as well as iota of judgments are there where Supreme Court has n number of cases has stated that look, this as soon as possible means a reasonable time. It doesn't mean it. You can't extend it 2 years, 6 months or so. So these are the three options. You can't go beyond these three options. Take a decision, but we have to mind it. In the Tamil Nadu petition, as you discussed, it is very categorically mentioned. They have asked the Supreme Court to give a time frame. In one of the prayers, this also. Now coming to your answer, your question. Well, this is something, if I may say, it is nothing but a political. They have to direct what what the central government is doing. They have to direct their governors. They have to pass at least they can give a kind of directions to the governors that they have to adhere to what time limit, what directions are given by the constitution makers in Article 200. So they have to just say so. And these governors have to follow that.
That's right. You're making an important point, and as you mentioned, the Tamil Nadu government's petition requests the court, seeks from the court an outer limit in terms of time frame for governors to decide on bills. Of course, the other issues have been settled largely in terms of the governor's role, as you point out, several judgments of the Supreme Court. But one is watching this confrontation very closely to see if there can be clarity. As you know, the vagueness in that time limit and that lacune has resulted in several such confrontation, as you point out, which have a political undertone to it.
It is nothing but an unconstitutional inaction, as the court today said. It is nothing but unconstitutional inaction. So this inaction should go. They have to act.
Well, that's an important point that you make there. We hope that constitutional inaction goes, unconstitutional inaction, as you say, goes. But thank you so much for joining us.